I believe the moderator would extend and expand my introductions when dealing with the panelists. Renale Re Kahomokotedi. Renale Me Mbewe. So we have in our midst representatives from Bokongo Rekololo and legal advisor from Botswana, Brian Ayrton. And by any mistake, if I have omitted anybody, let me acknowledge all in attendance. But we have senior government officials and the rest of you in attendance.
Ke a leboga molaodi ke dumela gore re phuthulogile ba gaetsho mme se ka se sebaka kana ha ke ra simolola lenaneo la letsatsi re se re amogelwe ke ene monga mo o ka kwano e bong Kgosi Thari ka wa khotla ya block 8.
Ya leboga motsamaisi tiro wa letsatsi la gompieno mente ke simolla ka madume ke re dumelang lotlhe la bagaetso ke tlhalogantse gore go na le kana go nganye buitswang se batho ba se buang ngangisanyo ka la constitutional court nte ke rialo mme nna ka boitemogelo ba me ka gore mo Botswana go na le mo go teng structure of courts di kote ka di tlhomaganang ka te e kana ga eyo ke dumela gore ke a e bata kana ra e bata nte ke rialo gore nne gore tle e hokotse mesuke mo dikhoteng tse dingwe mme gape ga ke ntse ke lebeletse go na le sello sa gore ga gona mebereko kana dikhote tse dintsane di batla di-professionals in law ke dumela gore go tla nna le mebereko ga ke na mahoko a mantsi kgatlhego e ntsi thata ya ka dingangisanyong batsadi nte ke re ke la amogetse mo phirimana gompieno re boloke nako. Thank you.
Ke a leboga kgosi gore o bo e tshwere ka boripana mongami mme ha ke utwa molaodi ha moragonyana hale o na rile ke ta tlolosa the introduction to our panelists gore le itse gore re biditse bo mang ke dumela ke re na le re ka go Mokotedi ke mothatella dithuto wa tsa molao ko University ya Botswana re be re nna le me Mbewe leina la gagwe la nthala mpalla tota mme hela ke dumela gore o ta intshwarela ke sa le pronounce sente Njirimanda Mbewe ene ele lawyer kana agente a tswa from law firm ya gagwe ya Mbewe attorneys re be re nna le Professor Bulale le ene ke mothatella dithuto ko University ya Botswana wa tsa melao mme ba gaetsho ga ke batla go dia sebaka se se kalokalo ke batla go tsana ko e ke simolole hela ke bulele yone kganye le gore e re kopantse mo tsatsi la gompieno. But before ke tswelela gongwe ke supe gore mo tsatsi la gompieno re kopanetse yone panel discussion ya Constitutional Court go ta go bua ka gore ke eng go tshwanetse ga nna le Constitutional Court. Sa bobedi re kopanetse go ta go bua gore mme yone Constitutional Court ya ka e pasitse ko parlamenteng bile a teng hitile e mo legatong le lentseng jang magato a latelang ke a ntseng jang gore Batswana ba te ba thaloganye dilo tse e tere le bone ka moso ha ile gore ba e gana kana ba e dumela be ba e dumela ka mabaka a leng teng be ba e gana ka mabaka a leng teng re ta tolosa tse dingwe go ntse go tsweletse. Ke ta ha re ka go Mokotedi sebaka sa go simolola our panel discussion.
Ke a leboga mo tsamaisa tiro ke a leboga le ba ba reeditseng puisano e ya gompieko. Ke dumela thata gore mo puisanong ya rona ke tla bo ke itebagantse thata le Constitutional Court bo molemo kana go tlhoka bo molemo jwa yone, not to pass a verdict on the process that has unfolded thus far. That is a different topic altogether. But the animal before us as the Constitutional Court, gore ke eng. But before ke tlhalosa gore ke eng, ke tshwanetse gore ke tlhalose ka go ha dikai tse e le go tlhogatsa go tlhaloganya gore phologolo e go tewa phologolo e ntseng jang. Le tla itse ba le reeditseng le Botswana ko gae, in our court architecture go na le court e itebagantseng le dikgang tsa pereko, industrial court. It's in the early 90s. In the early 90s, go to industrial court to address industrial disputes. Go tsereganya di pharologanyo tsa pereko la itse akere. Go ne ga nna le mone go twe ke the land tribunal. A kitso yone la itse. The land tribunal e be nna teng. Purpose ya yone e le go tsereganya dikgang tse di amanang le lehatshe, land tribunal. Mme ka bontsi go ne go le megolo kwane ha di court tse di itebagantseng le selo sengwe ne di tlhamile mo Botswana. Babereki, trade unions ba amogetse industrial court ka matsogo mabedi. Batswana ba ba neng ba lela ka dikgang tsa lehatshe di sena court e itebagantseng ebile e specializer mo dikganyeng tsa lehatshe rile tlhamiwa. It was a welcome development. The Constitutional Court e tla nna court e nngwe gape which will be a court of specialization. Le yone e tla be itebagantse le sengwe. Hela jaaka court ya babereki itebagantse ka tsa pereko, land tribunal itebagantse ka tsa land disputes. Constitutional Court e tla be itebagantse le dikgang tse di amanang le one molao motheo, as the name suggests. Constitutional Court. Kgang e pe leng gore is dispute can be traced to the Constitution. Kgang e pe leng gore ope o batla go vindicate his or her rights tse di bo molao motheong. Constitutional Court tiro ya bogolo segolo e tla be itebagantse le tiro yone eo. Mme be go raya gore yaanong e nna yone court e tona mo go tsone ka melao yotlhe mo lehatsheng e e tsaya boleng jwa yone mo molao motheong. So the Constitutional Court will be a court of specialization. It will not entertain or listen to any legal dispute. A constitutional matter, issues bordering on human rights, di tla bo di itebagantswe le Constitutional Court. So pele ga re simolola any discussion, it is important to locate the Constitutional Court within the existing legal structure. Because once we understand its purpose, we then begin to appreciate its usefulness. Gora gona le lekgotla e le gona le letona le itebagantse le constitutional disputes, protection of human rights. But the utility of this court kana boleng jwa yone le botlhokwa jwa yone mo setšhabeng bo tshwantse ba simolla mo go e tlhaloganyeng gore tiro ya yone ke eng. I don't know if there's a question. Yes. So that is why we need to understand tiro ye court e tla beng e dira. So mo mahatseng a mangwe ke court e leng gore ga o lebelela mahatshe a mangwe lekgotla le le teng lonele e tla be se tlholontšha gore le nne teng mo Botswana. le teng le mo mahatsheng a mangwe mo Afrika le teng ka ha mokgwa le berekang ka teng kana ka ha mokgwa le berekileng ka teng mo mahatsheng a mangwe le gone tla re ntse re tsweletse ka puisano re supi gore mo mahatsheng a mangwe le kgotla le berekile yang le hitlheletse eng le kgonne eng le paletswe ke eng ntswa ka tshekatsheko ya me go ntse le bo molemo jo bontsi ha le kgotla le teng. There are cases where they are not benchmarks. Go na le mahatse a nang le constitutional court a e leng gore boleng jwa puso ya batho ka batho bo kwa hetse la bohelo. We have to be honest about it. E be go na le mahatse a nang le court ya mohuta o a e leng gore mahatse a mangwe a meletsa mathe to nourish constitutional democracy. Le khota le la constitutional court le tshamekile a pivotal role mo go nonotsheng tshwanelo ya ba tshireletso ya tshwanelo tsa batho o intshwarele ra ke nna ke re sekgowa Setswana. So the court has played a vital role in entrenching democratic principles, in entrenching constitutionalism le tshireletso ya ditshwanelo tsa batho. Hela ga re se kgakala mahatsa tshwana le bo Afrika Borwa o kgona go bona constitutional court e tshameka a decisive role in the constitutional affairs of the country. Go na le mahatsa a mangwe gape a nang le court ya Tebego a e leng gore makgotla ao a ntse le sabe to weaken democracy a teng lona mahatse a ntseng yalo e tla re ntse re tsweletse re tla ya tolosa go pele re
ke a leboga re ka mo halegofi ka se sebaka ke ta ha mme Mbewe gore lena a lathele.
Good evening, Dumelang, ke a le dumedisa, motsamaisa tiro and everyone here. For me, my opening statement would be, now the time has come for our democracy where there needs to be the existence of a structure is going to protect our human rights or our rights. There is nothing more important than the protection of your rights. And we have been admired as a democracy. A lot of countries look at us, Botswana is a democratic country, it's a peaceful country. We've really been admired. But in order for us to really reach the end product of the excellence of democracy, I believe there has to be the existence of a constitutional court to protect the right of every Botswana. Over the years, in practice, I have seen how courts have failed to interpret the tshwanelo tsa batho, especially pertaining to the constitutional rights. They require the expertise of constitutional judges who would be able to interpret, because interpretation of the tshwanelo tsa batho or interpretation of constitutional rights is broad. And at this point, we have reached the time when it is essential that this court exists. It's not about yesterday. In fact, it is as urgent as yesterday. There is no harm right now for our country to have this court in existence. And we've seen instances where people's rights, I mean, there are many examples over the years where matters have gone to courts, but the interpretation of human rights has not really been at par. And so the time is actually now. And I believe that the question is not about a court. The question is an institution that is going to protect in the strongest possible terms your human rights. There is no harm in the existence of a constitutional court. In other countries, in other democracies, Jaga Remkoti has spoken, it exists. So really there is no harm, and there is no need for us to not have it in existence because of other reasons. So I would urge us as Botswana to say, having our rights being the ultimate and most important thing to us, this is the time for us to ensure that we protect, especially looking at the fact that there is evolution and we've reached that stage where existence needs to be there. There are a lot of rights which are not being enforced because we don't have the specialization that a constitutional court would be able to provide. There are different courts. We have the commercial court that's dealing with commercial matters. We have the criminal court that's dealing with criminal matters. And so looking at the highest possible right that Botswana has, the Constitution is the foundation, the supreme law of our country. I believe now is the time. Yesterday was actually the time. It's taken us a long time. Democracies which are younger than us, looking at South Africa, South Africa got its independence recently, but they have a constitutional court. We have been using their jurisprudence, mo Botswana. We've been using their advocates and their lawyers, mo Botswana. Now is the time for us to really position ourselves as a country in terms of being an ultimate democracy and having a court that is going to protect the tshwanelo tsa rona re le Batswana. So for me, I think the time really is now. Thank you.
Ke a leboga membewe ke ta kopa Professor Balule gore a latelela gagwe ba ga pele ga o tswela prof ba ga le ta intshwarela gongwe ha le bona ke batla go ba ha sebaka gore ba kgone go atolla dikgang tsa bone e ta re ntse re tsweletse e be nna gone re le kang go ba ngota in terms of nako merta ruri hatsa gore re tshwara nako sente. Thank you.
Ke a leboga motsamaisa dipuisano tse dumelang Batswana re le re mokotedi a simolla ke utela bua Setswana ne ka ikutwa ke huhula yana gore nna ke a go bua sekae ka Setswana ka re tsamaya sentse se thaela gongwe ke yone nthangwe le gore ire gore le nna ke be ke bona gore re batla constitutional court a se rongwe ta ira gore puo ya me le nna ke kgone gona ke bua ke phuthologile ha ke tebe ke le teng. Okay, with that said, ke dumelana le the two colleagues here gore the establishment ya Court of Appeal mo Botswana is long overdue. Hela jaga re mokotidi na thalosa. The Constitutional Court is a specialist court. What we have now, our judges are not specialists. They are generalists. So I think the current Chief Justice trying to reorganize the judiciary, specialist courts, criminal law, maloba ona atama commercial. So I think it's also time that we establish a constitutional court. At the moment, the High Court is currently playing the role of a constitutional court. So the question therefore will be, has the High Court effectively played its role as a constitutional court? We are a constitutional democracy. We believe in the separation of powers between the three branches of government, being the executive, the legislature, and the judiciary. We have seen our parliament passing laws that are in conflict with the Constitution. And this is the importance of a structure such as the Constitutional Court. We need a court that will be independent of both the executive and the legislature, which will have powers to ensure that acts of parliament, acts of the executive are within the Constitution. So having said that, how has our courts fared when it comes to settling the disputes about the Constitution? I know people will point to one or two cases, the citizenship, famously known by the case of Dow and the Attorney General. Then there is another one, ya Lekhabibo. So people actually point to those. Yes, those are very progressive, judgments, but we also have many judgments. Our High Court has failed us, and one of the main problems that we have in our current court is that Section 18 of the Constitution tells you that if you feel that there's an act that infringes upon your rights, the High Court has powers to do so. But the very same court has also said we have the power not to decide on the constitutionality of an act if there is a way that we can decide your complaint without deciding the constitutional question. We have many laws in our statute books. Some of them were enacted during Nagwarama Musadinyana. And then 60 years into independence, how do we still have such laws in our statute books? We are a democracy, but we have maintained some of the very old laws that were actually used by the colonial government to suppress very important rights like your freedom of expression and your freedom of association. And it beats me how for 60 years we have actually retained those laws. And when some people who have been charged with these laws brought these issues before our High Court, then the High Court decided to hide behind this doctrine of constitutional avoidance. We can't. We need a court that can actually say with certainty whether a particular law is constitutional or not. We don't want a court that will actually hide behind deciding what they perceive to be controversial issues, to say, no, we are not going to decide on this one because we may step on the toes of the executive or the legislature. So we need a dedicated court which will not hide behind stories like constitutional avoidance. How has our constitution grown? I've said that when I look at our jurisprudence, as Mambe was saying, that we are now relying on jurisprudence, the courts of South Africa. But we are quite a more mature democracy than South Africa. And I believe that our law is 30 years behind. 30 years behind. I have been in academia for over 30 years. To be precise, this is my 33rd year, 33 years. And it still pains me that when I want to write about laws or comments about laws, Samo Botswana, I keep on referring to Melawea South Africa, decisions of South African courts. Why? Because I feel that our courts have failed us by developing our law. It has failed us by developing our jurisprudence. So I therefore feel that the time is now that we have a dedicated court that will deal with our constitutional issues. We need that court so that it can enhance the protection of our fundamental rights and freedoms. Ketlaemaha for the time being.
Thank you very much, Prof. Balance in Logoro Harala Mogela. We have appreciated Hore Haribuaga Constitutional Court, Kepologolo in Sinjang. And then address the public concerns that are there with regard to the establishment of the Constitutional Court.
O ka ikgatlholosang matshwenyego a Batswana mo lekgotleng ebile re tla bo re sa ba direle bomolemo ha re ka itlhokomolosa matshwenyego a ba nang lone ke matshwenyego a ke dumelang gore a genuine. I know, Prof, in one of my write-ups, I took a very critical view on what I characterized as intellectual dishonesty from those who know but yet critique the Constitutional Court. Ke bone ba eleng gore gangwe le gape ke palwa ke go ba itshwarela ba ba le kang go timetsa setšhaba mme matshwenyego a setšhaba one ke amogela gore boleng jwa one gore ga gona melemo ke eng re sa tseye madi a constitutional court re reke molemo re baakanye A1 re reng ka tshekatsheko at face value these are genuine concerns. Mathata a re nang le one ke gore ga o bua ka tshwanelo ya motho ya botshelo le tshwanelo ya motho ya botsogo le tshwanelo ya motho ya freedom of speech ga o ka ke wa re o di ba mo sekaleng ke baya tshwanelo ya freedom of speech ka ha ke baya tshwanelo ya freedom of association ka ha ke he leng gore e tshwantse gongwe ya tla pele ditshwanelo ga di bereke jalo ditshwanelo tsa motho tsotlhe le dikgololosego tsotlhe tsa motho di tshwanetse tsa nna le boleng le bokete jo bo lekanang ka nako tsotlhe ga re re nyame re ntlhaile le mo palamente re ka rama re go tsetse tshwanelo ya freedom of speech mme ra go haya botshelo potso e nna gore boleng jwa botshelo ke sa kgone go ntsha se mahatleng ke eng go na le o tla buang gore ha o ntsela tshwanelo ya go bua mme ke tshela go tshwana le kisule ra dumelana yo mongwe a ba go ra re nya wena o ka tshela ra go ya tshwanelo eo mme re go kganela gore o se ka wa joina mokgatlho wa pelo ya gago a ke kereke ya Sioni a ke kereke ke bolo kana ke o he mokgatlho o pehela a ke ra go itsa tshela ka bonosi hela ka gore mo go botlhokwa ke botshelo gore nyame ga o nkitsa go nna mo Sioni le go ba mako Sioni go tshwana ile kisule a ke re go ntsalo so le tshwanelo ya botsogo ke tshwanelo e leng gore e botlhokwa and no one can undermine it mme ga o ka ke wa re ke batla botsogo gompieko mo go irang gore tshwanelo tse dingwe di sireletswe go kana magwemi phadisano e ntseng yana ditshwanelo ga ena it has no value ga gona sepe se o ka se robang gore mo nakong ya gompieko mphe tshwanelo ke batla go bua hela bangwe ba botsa mo Botswana ga rena tshwanelo ya botsogo a ke right ke ra mo molao motheong a ke right ga rena tshwanelo ya bonno jo bo nang le seriti a ke re ga rena tshwanelo ya eng gape ga rena tshwanelo mo molao motheong ya metsi a phepa water and sanitation ga rena tshwanelo ya teng a ke re mme yo mongwe go rare ga ke sena tshwanelo ya thuto boleng jwa botshelo e nna eng ga ke sena tshwanelo ya botsogo the right to health what is the value of my right to life a ke re gone mo go supa gone gore tshwanelo tsa motho le dikgololosego tsa gagwe ga wa tshwanela gore o di lebe ka phadisano ka litho la phadisano emisa constitutional court e emise pele ya go tsaya madi a teng e go thiba pothole kana tsaya madi a teng re ke pilisi at least from a constitutional point of view phadisano eo ga ena boleng tota e bile ga eyo a ke gore ga o ka ke wa re ga ke batle court e siretsang ditshwanelo tsa me nna mo ke go batlang hela ke go batla molemo hela tshwanelo ya Motswana ke go batla diotse ka nako e nngwe hela ka gore ke ditshwanelo tsa gago tse e leng gore ra re they are inherent hela ga o tsholwa o belegwa hela ga o belegwa tshwanelo tse o na le tsone ebile ga o di kope mo go goromente ga o re goromente o re ke kopa tshwanelo ya botshelo ke kopa tshwanelo ya kgololosego ya go bua mahatlhami o na le tsone ka gore o mo botshelong yaanong Batswana ba tla ba itirela Setswana sa pala prof it will be an injustice e re itirelang re tabo re itlhokisa tshiamo rona ha re batla goromente a re neele tshwanelo ya AB tshwanelo ya CD e kana maeme pele nya le ditšhabatšhaba di ka re tshega ke ra ditšhabatšhaba di ka re tshega membe ona a bua gore mo mahatsheng Botswana o meletswa mathe ka gore it has a mature constitutional democracy. Ke puso e ikaegileng ka molao motheo, the rule of law, separation of powers. Mme ga batho ba ba re meletsang mathe ga ba ka utlwa re re tshwanelo e re e batlang gompieko ke 1 2 3 4 nya re ka e bona next year ditšhaba di ka re tshega. Ga e le sengwe nka utlwa e re batla botsogo ka ke tshwanelo ya rona re le batho a kere re batla botsogo, mme ga go a tshwanna re go batla botsogo go nyenyega tse botlhokwa le potlako e tlhokagalang ya constitutional court. A ke tswela ke go arabile mongane era thank you.
Ke a leboga re Mokotedi. Pele ga gongwe ke ka ha membe wa sebaka prof kana gona le kgang e leng gore ke a moruthuta mo Batswaneng, kgang ya gore go tisa constitutional court before go nna le constitutional review ga se gone, gongwe o tlhalosetse Motswana yo reditseng le ba ba hano gore boammaaruri ja kgang eo keng.
Tekile ke go araba ha a ke tse ke bua le Batswana go lebega ka re ra dumalana gore molao motheo wa rona o tshwanetse gore o baakangwe. I think there's a general consensus that there is need to review our constitution. Nahela ka bonosela, I'm not so convinced that we need a comprehensive overview of the constitution. Mihela go lebega ka re Batswana ka bontsi ba batla gore molao motheo o sekasekiwe. Me potso ke gore a me re dumalana gore ba tai mo molao motheo. Is there any consensus on what we want? I want to give an example. One may actually want a review of the constitution to look at institution ya bogosi to give them more powers. Nahela ka bonna, I mean, feel gore we don't need institution ya bogosi. Harisa dumalani, how do we then reach a consensus? And then I'll take another living example. In a democracy, we talk about equality, non-discrimination. So discrimination based on color, sex, creed, and sexual orientation. So we have we refer to as sexual minorities. So le bona bana le tshwanelo. Gantsi ka tikuti batho ba re nyana ka tumelo ya me ga go a tshwana go nna jana. Bangwe ba re nya ka ngoya rona ga go a tshwana go nna. Democracy protects minority rights. So we cannot allow the majority to ride on the rights of the minority. So the question therefore is, how is there a conflict amongst us? Who actually has the ultimate say? So in my view, we need the Constitutional Court to be the final arbiter when you are not able to agree. So for me, when you look at the nature of constitutional courts, they also have that special power to be the final arbiter, to look at what people are proposing. Because democracy is not only about what the majority says. Democracy is also about protection of minority rights. So in my view, especially in Botswana, we need a constitutional review. But I'm not so sure whether we actually agree on how that final text should look like. I foresee that there will be contestations. There's going to be arguments about whether we want this or that. So in my view, we will need a constitutional court to then come and say, no, what you want, even though you are the majority, is not in line with a human rights-based or constitutional government. So I think for me, that's the importance of having a constitutional now, so that it can then guide us during this process of constitutional review. And let me say this, the process of constitutional review is going to be a very long process, let me assure you, minimum 3 years. And it should not really be a project of the government of the UDC. It should be a project in Botswana, so that even if there is a change of government in 2029, we are still able to continue. Because we want a long enduring constitution that protects the rights of each and everyone. So from that perspective, therefore, I would say I see the agency of putting up that court now, so that it plays a supervisory role in the constitutional review process. Thank you.
Thank you very much, Prof. Member, the Constitutional Court, ya go sireletsa yang ditshwanelo, especially tsa bomme and the minority?
Currently, we actually do have a case which is dealing with 2 females, and that would have been a perfect case that should be placed, or would have been placed before the Constitutional Court, because they would have the expertise to be able to deal with it. Having practiced for 14 years now, I have seen how these laws that are already in place, how they can be discriminatory. I will give an example. We have the Industrial Court, which deals with labor matters. But sometimes it's not just a labor matter. When you really interrogate a matter, you are able to see that there's an underlying issue with respect to the rights of particularly women or marginalized communities. One example I've come across that I've realized there was an injustice, or there is an injustice, is that when I look at matters that deal with sexual harassment in the workplace, there seems to be not so many precedents or case law with respect to that. So my question becomes, over the years in the workplace, are we saying that women are not being sexually harassed, especially in the context of, for you to be able to get employment as a woman, I mean, we must concede and accept the setting has predominantly been a patriarchal setting. So the question then becomes, if you want a job as a woman, there are advances that are made to you with the current system to say you can get a job if you are then going to give me this particular favor. When you take that matters before the Industrial Court, sometimes the court itself does not really have the expertise, the special expertise to address the sexual harassment matter in the workplace. This is something that a lot of us as women or women complain about. We complain about it a lot, but you hardly ever hear a matter where a woman gets redress or a woman is assisted with respect to sexual harassment, because there is a need to understand what creature are we dealing with when we say sexual harassment. It's not just an issue of being at work. It also goes to the gender and the power dynamics of the employer being a man and the employee being a woman. So it is very important and very critical, especially for us women, looking at how we want to advance our rights in terms of having an institution that can understand. It's really a gap. It's a gap, and also I would say it's unique. It's sui generis, it's unique. It requires a certain mind, and that mind, in my opinion, would be a constitutional court. By now, if we had a constitutional court in place, I believe we would have a plethora of cases which are dealing with the protection of women in many places, including the workplace. But those cases are not there, because when we are trying to explain sexual harassment to certain courts, they don't quite understand it. It's not just about being an employer or an employee. It's really about how my gender or who I am has a bearing in the setting of equity or in the setting of equality. And so it is very, very, very important. Even though some rights may not really be there in the Constitution, the broader interpretation, like I said, the Constitutional Court will be able to interpret broader to say it's not just about work, it's about the fact that you are a woman, and this injustice has been done to you because you are a woman, and then we'll be able to uphold your fundamental human rights. And these things go to dignity. When we speak about gender, we speak about it loosely. We are not speaking about it in the context of feminism, or it's about your dignity as a human being. And for me, there's nothing that could be more important. And so I have seen many times the failure of courts to protect and uphold our dignity as women in many instances. And a constitutional court would interpret that broadly with respect to protecting such rights. And we would by now have many cases. As a woman, you won't have to give any advances to get a job because it would be clear. But at this point in time, like I said, I have to look at South African cases and explain South African cases to judges whom may not really fully, and I say this respectfully, have the expertise to address that. So it is crucial. Thank you.
Thank you very much.
What Prof. Balule was saying on a court being the arbiter in case of a dispute of different interest groups. You know, South Africa has a very famous constitution, widely admired, its constitution. I don't know if the panel, are you aware of this thing? Hona le bangwe ba ba reng molao motheo wa Afrika Borwa ke mengwe ya melao motheo e leng gore rileng. It is internationally admired, the South African Constitution. But are you aware that the Constitutional Court refused the first draft to certify it? The very first draft, after it was Parliament had voted for it, approved it, it went to the Constitutional Court. The Constitutional Court sent it back to say, the terms of reference that the Constituent Assembly had agreed on, go and fix this and this and this. So it also plays a role in certification, to certify the Constitution. But what we must also highlight is this. A constitutional court can come first, then the Constitution. Or the constitutional court can be a product of the Constitution. So these are really the two models that can be there. In South Africa, the Constitutional Court was set up to certify the Constitution. Yeah.
Okay. No, thank you very much, Ramukotiri. In a layman's language, le thalosetsa you're a constitutional court. Why is it important to be established? Kaore renale Court of Appeal, renale the High Court.
Okay. That is a good question. For me, Prof. Balule is right to say under our current constitution, the High Court plays the role of a constitutional court. Okay? One of the foremost advantages of a constitutional court, it lies on the issue of direct access. You have a constitutional court, you have a constitutional dispute, you go direct access to this constitutional court. It gets ventilated, there is a judgment, it is also a court of first and final instance. Under the current architecture, you'll go to the High Court, as many people have done. The High Court grants a judgment. Either one who's not happy about it takes it to the Court of Appeal. So now there is a double-layered approach to protection of human rights. You go to the High Court. If the government is not happy, or if you are not happy, you can go to another level. But the Constitutional Court, its establishment, it will create a direct access mechanism. You don't need to go anywhere else, the double-layered system. You petition the Constitutional Court directly. It becomes a court of first instance and last instance. So in that way, the resolution of constitutional disputes becomes expedient, swift. So the protection of human rights, it escapes from that High Court, Court of Appeal layer. But yeah.
Thank you very much. Kutwa mongwangongore ga morago ke tale ha sebaka sa gore le lona le la thele le skala hela pelo. A kere ke ra gore ba letse ileng gore se tsere di itse rothe e tere ko pheletsweng ya letsatsi re ha re na specific to the case tsa rona. Mme gongwe pele ga ke le ha sebaka gona le ngwe e tsile mo thogong ya me gone jana gongwe ke kae le baganya prof ka kwa gore a mpolele gore ke ta tsela ba kgaolo a rona ya Gaborone North mohago ka gore tota ra arrangeitse this setting gore re tere khona gore re bue le bone. I'm just going to give an example. Re na le kgaolo ya Gaborone North suburbs ba ileng gore tota ba na le sello se se tona, sello sa teng ke sello sa ditsela bo metsi jalo jalo, mme o iphitlhela le gore one molao motheo wa rona ga gona go pega o buang teng ka a freehold land le gore ba tshwanetse ba thuswa ke government kana ba tshwanetse ba ithusa. So ne ke batla gore gongwe o yame re tere uto gore me ba ka thusega ha gona le constitutional court kana jang.
Kor ha ka lebella molao motheo wa rona kwa 1966 1966 how lebella the human rights. We have what we call first generation rights, which are the civil and political rights, which you find in the International Covenant of Civil and Political Rights, 1966. Then you have the second generation rights, your right to environment, these socio-economic rights. So you find that more, of course you can't compare Molao Motheo wa rona to South Africa's. Molao Motheo wa South Africa in the 1990s, when the law is not stagnant. So there's always that evolution in the law. Let me give an example of India. India has a very old constitution, which doesn't have these second generation rights, but their courts have interpreted the constitution to embrace those second generation rights. And our courts have constantly said the constitution should be interpreted in a way that will breathe life into the constitution. So if we had a constitutional court, I believe it would have been brave, just like the Indian courts, to embrace these second generation rights, the socio-economic rights, your right to health, your right to education, the rights that are enjoyed by indigenous people. And here, we forcefully removed people from the Central Kalahari. We made them to abandon their way of life. We relocated, resettled them, thereby interfering. So these are rights that are covered in this the second generation rights. So I believe that if we actually have a dedicated court, because in the interpretation of rights, such courts, how these rights have been interpreted. So I have no doubt in my mind. So that is why I was saying, I'm not so convinced whether we really need a comprehensive review of the Constitution, because if you have a constitutional court that really takes its role seriously, then we may not need a review of the Constitution, our courts or the Constitutional Court will adopt a purposive interpretation of the provisions of the Constitution to breathe life into the Constitution.
Thank you very much. The last one, Ramokotedi, quickly take us through the process of establishing a constitutional court before
Yes, thank you. So Parliament has now voted on this bill. It now goes to a referendum. Botswana needs to voice out if they indeed support this court or not, because it is one of the most consequential amendments to the Constitution. So ultimately, iya ko Botswaneng gore e nne lona ba le nang le katlholo ya bohelo ebile ka gore khote ye ga te tlhamelwa lona e swantse a nna lona ba le tla supang ka tlhopo gore a khote ye la ya mogela gore e dirwa on your behalf kana ga le batle ope yo sa e batleng yo kana yo e batlang o ka gakolola o ka ntsha a gwe mahatla. But ultimately go supa gore ke khote e senya the present government kana ya babusi ke sone e tlhoka gore lona beng ba molao motheo. Of course we know gore molao motheo o tota yo ga re ise re tse sa be sepe mo go ne me re wa mogetse one a ke ra dumelana with its imperfections on how it was adopted. Lona beng ba yone ka khote ga didirelwa lona le go ha katlholo a bohelo ene katlholo e leng gore la go enela go tla bo go sena pe e leng gore o ta tswelela a ntsa ira yone panel discussion kana a debate te tla bo le buile ga re batle khote e kana re batla khote e. So ke gona tota mo e leng gore go setse. What now must happen before this referendum, in my respective views, ke intensive structured public education. Structured public education. Because in my view, it is not only about you exercising voting yes or no. It is about informed participation. O tshwanetse wa bo o itse what is at stake, go tlhophiwa eng, o raya e mo go eng, o raya nya mo go eng. This is where I honestly, personally believe a lot of government resources, a lot of NGO participation in rolling out massive public education. Ga o ka lebella mahatshe a tshwanang le bo Kenya, they have one of the best case studies how even public education was rolled out. The money spent on public education, it far exceeded the money for the referendum. Public education, going to each and every small village, not the A1 big villages, no, deep in the bundus, explaining and educating our people what this constitutional court is all about, so that when they vote yes or no, they properly understand this animal.
Thank you very much. Okay. Member,
yes, just to add, when everything is taken away from you, the only thing you will have is your rights. For all these other things that are there, when that is not there, the most fundamental and important thing left is your rights. Do not wait for your rights to be violated first, and then you reach the Court of Appeal, and the Court of Appeal is the last court hearing that matter, and you do not get assistance. That's the end of it for you. But here is an opportunity for you to have an institution that is going to protect you when everything else is taken away from you. So don't wait for the violation. Protect your rights now. And do not say other people are being violated. You never know when your right is going to be the only thing and the most important thing, which it is. And so that is very important. The structure of the fact that with some of the cases we have done, when we have reached the Court of Appeal, there was no other place to go to. And we could see that there is a violation here of an important right. But with the existence of a constitutional court, you will know that if it is a constitutional matter, there will be another place for you to go to, a final place to go to, where that can be determined. So let's not wait for your violations. Let's protect them now, not only for ourselves, but for the future generation as well.
Thank you very much. I'm going to take 2 questions from this side, 2 questions from that side. Ke kopa hore ha le botsa dipotso le nne precise gore re ska ra dia sebaka. Era.
Thank you for the record. Kibidua Frederick Solomon Kolol. It will only be fair that we educate the public as you do or the experts did. I may not ask a question, so then that we all are informed. A case for South Africa. Between 1991 and 93, during the CODESA negotiations, that's what led to the establishment of the Constitutional Court, because they were dealing with issues like Group Areas Act. Group Areas Act, that is what it meant. In Kenya, the case for Kenya, in Kenya for the longest time, their amendment, their review, I think it happened around 2018-17, if I'm not mistaken. For 20 years, they've been reviewing it, they've been talking about constitutional court, constitutional review, and so forth. The Kenyan case is that, among other issues, women did not have rights in Kenya. The legal experts should know. In Kenya, for the longest time, as a woman, you would have to have a man, whether he's your husband or your sis or your brother or your uncle, for you to get even a service loan. Mosadi ko Kenya for the longest time. This is what led to the constitutional review and establishment of this court. Case for Zimbabwe. Zimbabwe for the longest time, it was not clear whether they can demonstrate by Bereki Baka Tsana Mustaratemba protester. It was led by Bo Morgan Tsvangirai. What is a case for Botswana? The civil society, we are saying it is time for a holistic constitutional review because we are sitting on a colonial document. When Merahe went to President Mogae Moagoro Balakakariso, Simula Gaborone North Constituency, the paramount tribes and the paramount chiefs. They went to a certain section where by change, Malazinga representative from Bubira, representative from Zopo, representative from Kalagati. So it was not addressed. When Kamana Kao said, Rebatla indigenous language, they went also to a certain constitution, but we are saying, we, when they went to court to say, Ronarele Batuba Bumbole Bungwe, Rebata or Lerle Tala or Kisune Mona, Mosadium, Mosadium, but so Topola Semahat. Civil society, eligibility hands go Kenya, go South Africa, Buankaene, Leko Zimbabwe. So here, Kidira Lakere. These are the things on the bill. Bill ye it is Yoko Parliamente. First point, there is no quorum for constitutional court hearings. This is the bill. It is Yoko Parliamente. Missing or separate of enabling legislation. Harona uncertainty or Harona certainty agore. Ki uhemola moto establishing pologolo eba buankayo. This is where we are, civil society. The separation of powers. This court concentrates all appointing powers on the president. All appointing powers on the president. Now, under constitutional law that they have read, there has to be an instrument in the constitution that will establish a constitutional court which then under this instrument dilo tse tsotlhe tse di tla dirisiwa gona gore ga gona khoramo dijai tsa ga dina khoramo jai tse di appointa ke tautona le nosi mola bile ya bone gongwe le gongwe ha go le nteng ha no go to high court ha go teng high court shall resolve this matter e replace go te constitutional court. High court shall resolve marital issues, constitutional court. So it is a bill that means nothing but changing of words. Constitutional court ga se just o tlo go le bolokang kana o tlo go bolokang setšhaba. The truth of the matter is that it has to be done properly in le ditsetla tse di tla sireletsa le bone ba ile gore they are propagating for it as it is. Go tabogetswe hela gore e dirwe ga re itse gore e direlang ka gore ga e se direle se tshwanetse gore an instrument like we are saying re le civil society gore instead of go ketlola gape a re changeng constitution ya Botswana re e beelekwa. It is an old constitution, it's an old document, it's a colonial document. Good lo bua ka contestation. Let us contestate re bua ka matimela a rona, re bua ka samorahe sa rona, re bua ka bokgalagadi ja rona la go nna mo ga ja diphologolo ga rona. It is our country, it is our land. And therefore when you talk of the constitution, you are talking about the soul of this country. Ga ra tshwana go tlheba ke ditlhong gore re rute batho gore ba maruri ke gore re tlhoka a holistic constitutional review. Iseng ya malo ba batho ba palame dikole ka puso ene e tswaele ba tletse mo ba review constitution e batho ba re bo moshiri ba bidwe bo eng. So ka bokhutsana ba gaetso, you need to educate yourselves about this bill, so then that when you go and vote go dikgotleng you know what you are voting for. Ga re gane constitutional court rare. Let us have an instrument which establishes this thing. So then that
Thank you.
Sabohelo, there is no appealant after the judges, after judgment of constitutional court.
Mari tare he ba bangwe sebaka ha sore ke a go kotela mokao lengwe ke tota ke itumela go itisa le bone ba ba opang diatla, because the main reason here this panel discussion is to have differing opinions so that our panelists here ba ka taba re thusa. Ga sore ke a go kotela ka lepehela ne ile gore ke he ba bangwe sebaka ba taba le bone ba ipubole era this two.
Mela magaetso leina ke Selweilwe ke monni wa Gaborone North, in particular Phakalane. Ke na le two issues se di ntshwenyang. Sa ntlha ke gore as ya ka se go kile ga itshupa Batswana ga re bale ka bontsi ga re bale. I'm glad gore mongwe ile ha bua the last speaker ona a tshwere the bill itself mo sa teng, and ka go tlong ka teng tota go botlhokwa gore bogolang ga re tla go tlhopha nako ya referendum re be re itse gore tota molao wa reng the issue behind the principle of the constitutional court. So nanga kopa in future debates or panel discussions go ne le go gongwe ha re fiwang mongwe ka tlanya hala ka bokhutshwana gore tota hala molao ne wa reng what is in the constitution, constitutional court, issues relating to ke dilo tse re di utlwang hela because ga re bale so gore tautura ke ra tla ba nga top members of the and people will have direct access to the constitutional court. So class ko pamba gore in future really just a short summary, even one page gore tota the bill it's in same mo teng ya reng. Sabobedi se se tshwenyang ke gore the current constitution ga gona go pa ha buang sepe ka constitutional review it didimetsela completely Yeah, no. So there has to be a census. Census is a tlhalosa gore ha go dira census go tshwantse go tweng ke bo mang report e hela kae ditlhopho IEC is there the within the act go tlhalosiwa gore ditlhopho after how long and the report from there you sa itumelle maduo o tla ikuela kae. So this and the limitation committee lone is very clear. How about the and who appoints them is also important. So I'm not. I'm worried to carry the due process. For instance, follow review our constitution.
Thank you. Ke tsa gore e utlwetse mme ne ke kopa ba ga rona gore a re se ka ra boela se ba bangwe ba se buileng gore re tle re kgone go hana sebaka tota. I want to give almost all of you a chance to ask a question, so just to go straight into your question ke kgone go neela yo mongwe sebaka se
ke a leboga ke bidio go sitsele senna ke monni wa Gaborone North. Ke bone invitation ye gore la lediwa this panel discussion ke be ke ipotsa gore re la letswa setse ene mo parlamente o re la letsa a sa vote le ko parlamente o re la letsa gore tle go reng re mo he information ya go irang ka yone kana re la letswa ile an education ya gore itse gore ya no go ya referendum mme ke be ke hakgamala gore ha ile gore ke kganya gore referendum o kare government o se tsa itse gore ra go vote ka ro se tsa publish tse billion ke ya 1st August 2025 e ya sumang gore gongwe re te re le e leng gore e ready gore be ya go present go parlamente a mme go mo ke good faith kana re hano go tsa dikgang sa bo helo ke tsana mo mahokong a gare soloilo ha a gore ke ne ke solehetse gore the panelist here ba ta tsena into the details of the bill ba re bolele gore bile ya reng not the periphery ya ka ne re utlwa kgosi ya re ya go ira ditiro ga gona go pego teng ya go ira ditiro gone so ke ipotsa gore go bua ka gae a re tsene into the details of the bill re bolele Batswana gore ra re constitutional court amendment ya reng in details e re hara go tlhopha be re tlhopha ka se re se tlhaloganya e seng ne kgantse di ka kontle. Thank you.
ke a lebogara ke tsa gore ba ga rona ke tshwanetse ka tlhalosa gore this panel discussion debate e na le scope sa yone se leng gore e rile re simolola ko nteng ke be ke le ka go bua dintlha tse pedi tse tharo so ne ke kopa botsadi jam jo bo totegang ka gore ke a itse gore ba bangwe re kgona go tarena le tshesego ya go ta go bua sengwe le mo parlamente gore re tere tseo re di buele ko thoko a re itebaganyeng le di panelists tsa rona ke ta tsa era yes.
Thank you very much and good evening. There's so much I could say. I could speak forever because, you know, with the greatest of respect, I disagree with most of what the panelists said because, as is being pointed out, I totally agree that, you know, if you have a perfect constitutional court, it can do all the things that you're saying over there. But if you look at what this constitutional court is doing, if you look at what the bill actually says, and what I would ask the panelists, if they could please contact Bokongo and get a copy of a document which says, Bokongo NGO discussion paper dated 31st of March 2026. It is posted on the Bokongo's Facebook page, but it's very difficult to even find it there. So I would please ask all the panelists to please read it. It goes clause by clause. It explains every single clause in detail of what this bill does. And I think it's the obligation of a government to explain to the people when there's a referendum. And I do agree that this is probably the most consequential piece of legislation that has ever passed through the Parliament of Botswana. And yet, all I'm hearing at kotlas and things is as if this constitutional court is some sort of magical wand, that it's just going to solve all the problems of Botswana. It's not like that. It's going to cost a lot of money. Each constitutional court judge is going to be paid a lot of money. The constitutional court is going to cost a lot. You know, this, basically what I'm asking is, please, I would ask government to please, when they go through these consultations, look at this document, make it public to everybody. You can dispute it, read it and dispute it, say it's rubbish, but please give everybody a chance to know exactly what the law says. I mean, the biggest problem, I think, with this bill is that it makes the Constitutional Court the first and final arbiter of any human rights. And also,
kindly conclude so that we can give you a
and also use the word involves. If something involves a human right, the High Court has no jurisdiction anymore. Can you imagine how problems that's going to cause? We heard just now about labor matters, maybe dealing with constitutional matters. Imagine everybody could. How are we actually going to decide when a matter must go to the Constitutional Court and when it can be heard by the High Court? Remember, if it's heard by the High Court, it's null and void. That's what this Constitutional will say. It's causing a huge amount of confusion. This bill is not fit for purpose. It should be scrapped.
Okay, thank you.
I'm sorry if I don't sound respectful. I'm very respectful. I'm just animated.
Thank you so much. Let me give them a chance to react to the questions and comments.
Thank you for the useful feedback. Let me start with the first concern. I don't think anyone in the panel have suggested that the bill is perfect. If anyone heard any one of us suggesting that the bill is perfect, it is a misrepresentation. I don't know, Prof, whether you said it's perfect. We are not saying it's perfect. That is the first one. It is not perfect, like any other law. The question is this: could the bill have been? Is there room for reform in what Parliament voted on? Of course, there is. I would be dishonest to you if I tell you that I like every text in that bill. I would be dishonest. And no reasonable person can say the bill is perfect. It's not. The appointment of judges, for instance, you were suggesting that it is the president who appoints. But he does so on the advice of the JC. The complaint is the JC is populated by the presidential appointees. Yes. So that is the complaint. That the JC is the one that recommends or advises the president to appoint. But the composition of the JC constitutes almost 99% of presidential appointees. Now, that difficulty, my friend, it is not introduced by this bill. Even under what Kololo calls a constitutional constitution, it remains the current dispensation. Even if we do away with the bill, the president will still appoint in accordance with the JC advice. And that JC, under the current constitution, will be similarly be appointed as in terms of the bill. That's the first point.
We have never had.
Can you please allow him to finish?
I was correcting you. You wanted to advance an argument that the president would appoint constitutional court.
Can you please allow them to respond to all the questions? I'll give you a chance. Give him a chance to respond. Can you please continue?
So we must now agree. The president would appoint after the JC. Do we agree on that? What I'm saying is this, is even without the bill, don't make an impression that the bill introduces something. It makes our position far worse. Even without that bill, he still appoints in accordance with an advice of the JC. That's one. Two, and I'm pro-reform. Let judges be appointed by a cross-sectional society. Let Parliament participate. Let NGOs participate. Let the public nominate judges. Let there be public hearings for judges. This is what I personally prefer.
So then how can you support this bill?
No. What I'm saying is
Let's
this.
listen to.
What I'm saying is this. Listen. I appear before the High Court. I appear before the High Court and Court of Appeal on a daily basis. Huh? And those judges, they are appointed by the JC, appointed by the president. Do I disrespect the High Court or look at it with suspicion? I don't. The law presumes that judges or judicial officers are fit for purpose, are fit for office. Do you agree? So I'm not going to castigate the Concord by reason of how the judges will be appointed, when on a daily basis, I argue matters before High Court judges who are appointed in a similar fashion with how Constitutional Court judges will be appointed. That's the first point. The second point is this, and this is your criticism. The Concord is dangerous. It will be a first and last court. Is it something peculiar to Botswana? You know it's no. A constitutional court which you can access by direct access, in that instance become a court of first and last instance. So you can't really scream that in certain instances, especially where direct access mechanism is invoked, a court can be first and last. In South Africa, there are many judgments where a Concord was a court of first instance and last instance. If I'm lying, shout that I'm lying. No, wait. No, wait. No. No, wait. No, I'm saying there are instances where the jurisdiction of the Constitutional Court,
can you
it is
okay, I was going to say, okay, maybe we didn't maybe we didn't go about it in the right manner, because I should have laid some ground rules before we started. Can we please allow them to react to your comments?
Okay. Yeah.
And then afterwards, then if we still have time, I'll give you another chance, because we are running on a short program.
So what I'm saying is this. There is the criticism to the bill. It is well-founded. What I'm saying is that criticism is not peculiar to Botswana. There are instances where a Concord can be a court of first instance. It is not always that matters reach the Constitutional Court coming from the High Court and Supreme Court of Appeal. That is why South Africa has what we call direct access mechanism. Are you aware of it? Yeah? So I'm saying, listen, I'm saying you petition the Constitutional Court for direct access. You must demonstrate something for the Concord to be a court of first instance. Okay, let's agree that it's rare. But let's agree, it will not be peculiar to Botswana for a Concord to be a court of first instance and last instance. And this is my position. If I had drafted the bill, I would have really done something different. But does that equate to me rejecting the establishment of the court? My answer is no. Is there room for reform or improvement? My answer is yes. That is where Bokongo, as civil society, comes into the picture. Comes into the picture. Don't throw mud at the court. Go house by house, village by village, teach and engage people. To say, we have no problem. I heard your colleague, Mr. Kololo. He says he has no problem with the Concord. He says he has a problem with the process. And these are two different things. We must not reject the court by reason that the process or a provision in the bill was inelegantly drafted. We must champion reform. And Bokongo must be in the forefront, in my respective view, in that public education. And through that public education, and through that public education, you may actually assist in correcting the process. Yeah.
Let's continue. We'll get back to it.
I just want to add to Ramokotedi's, you spoke about costs. I do not appreciate the fact that we are equating the salary of judges, the establishment of a court, to the cost of a right. What cost can you put to the violation of a human right? There is no cost. It's priceless. The protection of a human right, or the protection of human rights and freedoms, is priceless. There's no amount of money that you can attribute to the protection. So the argument that it will cost an amount of money to establish something that is going to protect a right that is costless, or a right that is priceless, that for me is not an argument that would hold. When you look at women, and you would not relate, I would. When you look at women, and we have a constitution that does not speak to the protection of our reproductive health care, I could argue, because we have the right to life in the constitution, I could argue that the lack of access for me with respect to reproductive health care could affect my right to life. And so I'm not going to wait for there not to be the establishment of a court that is going to protect that particular right, or rights that deal with the protection of women, or reproductive health care, or instances of violence. In South Africa, the Constitutional Court has stated that in the Carmichael case, the fact that a woman is not protected in a GBV matter, the institution itself is brought to book for that. That is the protection of a right. So we cannot put a cost to the protection of a human right, or the violation of.
Let just me quickly react to the question raised by the gentleman from Bokongo. Is this somewhere? Bokongo, yes. Yeah. As Ramukotedi is saying, I think I do not hear you to be disputing in principle that we need a constitutional court, but perhaps you have issues with the contents of the bill. And I entirely agree with him that perhaps Parliament could have done a better job. For example, normally the composition of the court should have been stipulated in the bill and not left to an act of Parliament. And there's also the issue of the composition of the Judicial Service Commission, where you notice that almost all the members of that commission are presidential appointees. So perhaps the debate, because now, as Resiloilo was saying, that we should actually perhaps have been focusing more on the contents of the bill. So there are those imperfections which I think, as civil society, as members of the public, we should actually be lobbying government to say, perhaps whilst we, in principle, we are in agreement with the idea of a constitutional court, but we feel that a better job could have been done by addressing 1, 2, 3. I think that's where we are.
Sorry, let's first react to the comments, all of the comments. Then I'll definitely give you a chance. You make follow-up questions if there's still time. Yeah. So, did you conclude, Prof? Okay. I think I should take 2 more questions. Yes, sir.
Thank you, Mr. Moderator. Good evening. Kibidu as a child, I'm the UBSRC president, also a student of political science and public administration. Well, I'm going to ask a question which the gentleman who was talking about CSOs was supposed to ask, I think. If I'm not mistaken, the civil society organizations were consulted on by the government. Their position was clear. We need to have a backbone, which is the constitutional review first before the Constitutional Court. Voting went on in Parliament. Now, even education campaigns like this are still ongoing. CSOs have recommended, and we're still going for a referendum. Now, the question I want to ask again, like the gentleman who seated in front of us, are we doing this thing in good faith or not? When those who have got in-depth analysis and are giving recommendation because they are experts of it, by the CSOs are saying backbone constitutional review first before the Concord. Society vote the referendum which is expected to happen this year or what? How do we expect the society to vote? Maybe not only surface reality, constitutional court versus the constitutional review. Are we doing this thing in good faith or what? Thank you very much.
Okay, thank you very much, sir.
Good evening. My name is Tony Ndlebe. In the past, we have seen efforts to amend the Constitution, starting with Section 77 to 79. Even lately, we have seen the Botelo Commission, whatever what is happening just before 2024. And then, Botswana Banseba Joanzo Makima Politiki, Hota Khanya political hijacking. Because Iota Wanganza, Tlauta Bansabata, Ho Hetola Constitution Hale Aitebeletse, Botswana Banseba Bua, Haho Kwanahale, Sebatswana Basebatang. So, Nakitumela Tata mo constitutional courting, Holega Hotisa that oversight element, Holega Hokana Kanya political hijacking, Holega Hokana Kanya the executive powerful arm, by Develis, Holega Hokana Kanya political partisan, Kidumela Tata constitutional courte. Ke lebeletse thata go thokana le molao wa ditshwanelo tsa batho jaaka o so mo Botswana. Constitutional court e botlhokwa thata. Batho ba jabeditswe bogologolo. Dibotelo commission mongwe le mongwe mo Botswana o na antse a bua a sa tshepe tsamaiso yone ke ko parlamenteng ke ko dikgotleng ke kae le kae. Golomo go gontle thata ga constitutional court go lebeletse go tsweng kwa since Section 77 go itela maabane helana. Thank you.
Thank you very much, sir. The last one here.
Ke mo detanya kwa ketso. Na ke di banana le constitutional court ka gore Batswana ba jwa ntsoma every day. How can lebella on in terms of kaha insurance? Motswana wa dumalana le ba insurance kana le ba insurance X kana company X or nya ke ta contributor le jutubela ka le baka le kana. Then ha ka helwa ke tiro mo tseleng. Madi a go a jewa ga khone go claim back madi a go tot lebella gore re saenetse se le baka le kana. Then ha le 10 mo lapeng kana le 20 mo lapeng bo leta le kwa di shwa ke monna le mongwa hela one broker ga nkoko a go mokwadisitseng a tlhokagala it's only 3 people ba ba leng gore ba ta mo cover the rest ba jelwe mo gore constitutional court ya go lebella di details tsone tse gore go ne level gore go se ka ga nna gope ba ba jiwang tsoma ra utlwana mo gore ba leng gore ga ba dumana le bone le constitutional court ba re Batswana ba tswelle ba jiwe ntsoma ke bone batho ba go nna yana well Batswana bone ba safara.
Thank you very much, sir. I think Reka react to those 2 questions. Yantani le kanya gore Billy ipasitse ko parliamenting and we seem to be holding panel discussion. Ko marago ga gore marago ga go thopia ga yone ko parliamenting. Jano gongwe ka gore mokalong ha le o na tsene late. Me ano ka ganka ke ka yaraba. Ka gore re hale na le teng ha ke bua ko nteng gore we need to appreciate the process e leng gore re mo go yone when it comes to the establishment ya constitutional court ke ne ke setse ke a mile ganya gone gore e se se phasitse ko parliamenteng so ha re le nteng re tshwanetse ra bolella Batswana gore go tsama ha kae go tsena magatwae so ke ta ha di panelists se ba ka sa gore ba ya tolose botoka.
Okay, I think I must admit that something was not done properly. These sort of engagements, we should have had them from the beginning, so that people should have had an input. Helaga Batswana ba nela dikakanyo tsa bone. Honorable, I think perhaps there was a rush to publish the bill and take it to Parliament without fully engaging Botswana as we should. I think the government will have to accept that they perhaps skipped a very important step. Perhaps I guess you are here. And going forward, is there anything that can be done, to cure the bill before we go to a referendum? And then, just quickly to respond to Resicheli, I think I made myself very clear. We should guard against copying. The South African Constitution has a context. The Zimbabwean Constitution has a context. South Africa, there was massive human rights violations. Both Zimbabwe, both Malawi, they were transitioning from one-party governments to multi-party, governments. Lerona, our constitutional review must actually have a context. So I just want to caution. Well, yes, we may need a comprehensive review of the Constitution. But like I said, whilst we may agree on that point, but there's going to be disagreement on what should actually go into that Constitution. And this is where I'm coming from to say you need a structure such as a constitutional court to be an arbiter where the public cannot agree what should actually go into the final Constitution. Thank you.
I absolutely agree with Prof here. In the meantime, because reform is, it's a process. So in the meantime, there can be an institution or an establishment that will be the custodian and guardian of our rights as we undertake the process, which may take a while in terms of the rights that we would fully want. Thank you.
Thank you. Okay, the only last question is in relation to good faith. I think it is largely a moral question than a legal question. But if the question is, has Parliament acted in any unlawful manner, the question will be an emphatic no. It acted lawfully. Did Parliament act morally? By not by not convening the public discussion prior to the vote. Yeah? It's a different question altogether. and it is a value judgment. But insofar as was a lawful process followed in passing the bill, we would agree, all of us here, that yes. Huh? So, but morally, it's a value judgment. Yeah, I would have, and there's a distinction, a fine distinction between what is morally right and what is lawfully right. I think, we followed the prescripts of the Constitution. Our process was legally correct, but with the good faith, really, yeah, that is the best as I can assist Parliament as a whole. Thank you.
Just to add, and if you don't, the beauty of a democracy, if we don't agree, when you go to the referendum, then you know what vote you're going to make, and that would close the chapter.
Thank you very much. Our program is very short and brief. We have discussed, we have engaged, I believe. Our panelists, just a minute to conclude or wrap up.
Thank you, Botswana Kohae, le babamo audiencing. The reality of the matter is that Parliament has passed the Constitutional Court bill. This is the reality of the matter. There is consensus that a lawful process was followed. Morally is another question. The ultimate decision is in your hands. That is the ultimate decision. Am I happy with how Constitutional Court judges are going to be appointed? I am not. In as much as I'm not happy with how judges are appointed in the current Constitution. Huh? Is there room for reform? Yes. Should we throw out this most consequential institution in our democracy by reason of imperfections? I think no. I think no. The Constitutional Court will play an important role in nourishing this constitutional democracy. We need to entrench constitutionalism in this country. We need to expand the contours of constitutional protection in this country. It is a step in the right direction. Is it a perfect step? No. But it is a step in the right direction. We must, as a society, and this is my view, we must avoid extremism. Something must be extremely right for it to be acceptable to me. I can assure you, even if this bill was given to Prof. Balule, my supervisor, my boss at UB, to draft, there will still be sections of society condemning certain sections in that bill. Let us accept. Even the gentleman from Bukongo, if you were to assign you this bill, no, I'm saying, no, wait, I'm saying, accept your infallibility. Even if the nation of Botswana, 2.4 million, we were to assign the two of you from Bukongo to give us a constitutional bill, let us accept. You are not messiahs. Some, wait. Some, Mr. Kololo, accept, and it's not a sign of weakness. Some will critique your draft. So civil society plays a very important role. I am a believer and a huge fan of civil society, public education, telling truth to power. But civil society must not adopt a holier-than-thou attitude. It is only our voice amongst all voices that must prevail. It must be a consensus-building exercise. Everyone moves from his own rigid position, trying to find the middle ground. And that middle ground, it is what is called the soul of the nation. It is not every proposition from civil society that, no, wait. I'm not discrediting anyone. Mr. Kololo, listen, I support the work of Bokongo. All that I'm saying is, as a nation, we must find a middle ground. Government must not stick to its guns. When you tell government, advise, government, reform the way judges are appointed. Reform. Government must not be rigid. It must listen to your advices, which I think as members of academia, we agree with that which you propose. Allow a multi-sectoral body to appoint judges. Even civil society and members of the academia, we must not be fixated on our own extreme positions. We must try to find a middle ground, which is a national consensus. That is my message.
Thank you so much, Ramkoteri. Every generation must decide its legacy. And we have been admired. Through the power of our vote, we have been able to define and determine what it is that we want as a country. And that time has come once more.
Please listen.
The time has come for us to define our legacy. We have that power in our hands. We've had that power before. We've used that power wisely. And so we've been given that opportunity to exercise that power again. And if we can, if it is in the interests of you as a Motswana, of your rights as a Motswana, the question is, what is the Constitutional Court for? Is it for a politician? Or is it for you as a citizen? Is it for a woman? Is it for a man? For those who are gender non-conforming? For you, the marginalized? If the answer is yes, then you should vote yes, because you have that power. But if you're not going to use your power wisely, and tomorrow there is a violation, and you reach the door is shut in your face when it deals with your dignity or your human rights, you have no one else to blame but yourself. Thank you.
Yeah, I think from the majority of the contributions that I've heard this evening, it does not appear that the majority of the people are opposed to the idea of a constitutional court, but that there are concerns with certain aspects of the current bill, like on the that it does not say who will be members of this court. And then there are also concerns about the appointment of judges. To me, these are legitimate concerns. And we can then look to government to say, well, people have seen the draft, they have these concerns. So can you assure them, or at least do something to address these concerns? Because I do not seem to be hearing people say, no, we don't want a constitutional court. We do want a constitutional court, but perhaps there are one or two things that we need to do to assure Botswana that this court is going to serve them. So I think my concluding note, Honorable Ntaile, is that, of course, this is a democracy. But I guess you have heard, both sides of the argument, and that you will take to our leaders.
Thank you very much, our dear panelists. Before we continue with our program, let me just commit to an open engagement. Le Bokongo will engage you separately because I understand that there is more that you want to talk to with regard to the establishment of constitutional court. But the engagement, I want it to be more on the reform, the bill that has been passed. So let's keep an open engagement after this program. So at this juncture, Bagaruna, ki tumela gore be le tsile ke tla ha ene mo parlamente wa Kgaolo, Assistant Minister of Communication and Innovation, Member of Parliament for Gaborone North, Honorable Shonen Tlaile Sebaka, sa go ira the closing remarks. Re ka emela ka dinao ra mamogela.
Motsamaisa tiro ya gompieno ba buisa phuthego ya gompieno lo le bo mantswitswidi ba molao ka dikarolo tsa lona tsa semolao ka ha lo le banka teng. Batlotlegi ma parlamente ba ba ka bong ba lehano, ma batlotlegi ma councilora ba lohano, baemedi ba makgotla a ikemetseng, civil societies, baeteledipele ba merahe ya rona kana ditšhaba tsa rona, baithuti ba lehelo le re leng mo go lone, madikolo re leng mo go yone. Mme ke lemoge gape ka ha go hapegileng ka teng banni ba Kgaolo ya Gaborone o Bokone, ke a lo lemoga batho betso. Bomma le borra rothe dumela mo phirimaneng ya gompieno. Mme ha go na le bangwe ba ke ba tlodileng ke sa ba lemoga le tankinela diatla metsing, re leka go taboga le one nako batho betso. Mme motsamaisi ntetlelele mo phirimaneng ya gompieno ke supe boitumelo gore lo bololehano ba gaetso gompieno lo tsa karolo ebile lo buisanya, lo na le seabe se se tetseng go bua ka dikgang tse di mašetla tse di amang dingwe tsa dikgang tse di mašetla tse di lebaganeng le tšhaba ya rona ya Botswana. Mo letsatsing la gompieno re utlwile megopolo e harologanyeng, re utlwile matshwenyego, re utlwile ba ba emang nokeng le bone, ra utlwa dipotso, mme kana sone seo ke yone puso ya batho ka batho. We have had different views, we've had concerns, we have had support, we had questions, and that is exactly what democracy looks like. Democracy is not built by people who always agree. It is built by citizens who are willing to listen, think, question, and ultimately make informed decisions. Before I proceed, Director of Ceremonies, allow me to extend my heartfelt appreciation to everyone who contributed to the success of this important public dialogue. Firstly, I wish to sincerely thank our moderator, Raitso Amogela Mokoena, for steering today's discussion with professionalism, impartiality, and great skill. Your guidance ensured the conversation remained focused, balanced, and constructive throughout. I also wish to express my deepest gratitude to our distinguished panelists. Thank you for generously sharing your expertise, insights, and perspectives on the proposed Constitutional Court. Throughout your thoughtful contributions, you have helped deepen public understanding and encouraged meaningful engagement on an issue of national importance. Please join me in applauding our panelists for their valuable participation. My appreciation also goes to Kosi Kenneth Tari for his welcome remarks and for his continued leadership and service to our communities. Borara jobon namburi biza buri puta ore tshwaraganya re le setšhaba. I further thank the district commissioner and all government officials who assisted in organizing this event. Right, so Malawi. To the management and staff of the Botswana University of Agriculture and Natural Resources, thank you for graciously hosting us and providing an excellent venue for this dialogue. To the students of Buan, representatives of civil society, traditional leaders, members of parliament, Babateng councillors, community stakeholders, and residents of Gaborone North, thank you for your active participation, your questions, observations, and contributions have demonstrated the value of citizen engagement in shaping the future of our democracy. I would also like to acknowledge the organizing committee, volunteers, technical support teams, security personnel, and everyone who worked tirelessly behind the scenes. Your dedication and hard work made this event possible, and for that we truly are grateful. I hope we all understand that the Constitutional Court debate is not really about lawyers, judges, or legal technicalities. It is about us and our children. It is about the kind of Botswana we want to build. Throughout today's discussion, one message has stood out above all others. Thus, the power must always be accountable. No leader lasts forever, but the Constitution remains. It is the one document that stands between the citizen and the abuse of power. Remukoteti. Regardless of who occupies office today or tomorrow, kgotla ya molao motheo lo ne molao motheo ke tse di nnelang ho ruri ga se tse reng ha moeteledi pele kana party he tswa mo pusong e bo etsa maka tsone ke sone se ke dumelang gore go nna ga lona lo buisanya ka kganye ba gaetso ke sengwe se leng gore se ta kwalwa mo ditsong go sa kgathalesa gore se re se dirang hano gompieno a ke se ka reng o se leba wa re nya ke se phepa kana se re nya mme ke tshipi ditontobo re ta tsamaya re ntse re baakanya mo tseleng. Many people ask why Botswana needs a constitutional court. I ask a different question. Why should constitutional rights not receive the same level of protection and specialization that we already give to labor disputes through the industrial court, jaaka go builwe, corruption through the DCEC, or financial crimes through the Financial Intelligence Act? As our society grows, our institution must also grow. The Constitutional Court is not about taking power away from Parliament. It is not about weakening democracy. It is about strengthening the foundation upon which democracy stands. Think of it this way. When you build a house, you do not wait for the roof to collapse before you strengthening the foundation. You reinforce it while the house is still standing strong. Botswana's democracy is standing strong today. The Constitutional Court is about ensuring it remains strong for generations to come. We have also had concerns about cost, timing, and priorities. Those concerns are legitimate. Citizens have the right to ask difficult questions. In fact, they should ask them. But we must answer those questions with facts, not rumors, with evidence, not fear, with understanding, and not misinformation. The future of our democracy cannot be built on social media speculation or political slogans. It must be built on informed citizens making informed choices. That is why I encourage every one of you, read, ask questions, engage, and seek the facts for yourself. When the time comes to make a decision, do not vote based on fear. Do not vote based on what somebody should be loudest. Do not vote based on what your favorite politician said. Vote based on what kind of country you want Botswana to become. If you believe constitutional rights deserve stronger protection, vote for the Constitutional Court. And if you believe future generations deserve institutions capable of holding power accountable, vote for the Constitutional Court. If you believe that no citizen, whether rich or poor, connected or forgotten, should ever stand alone when their constitutional rights are threatened, vote for the Constitutional Court. And if you believe that Botswana's democracy should continue evolving, strengthening, and maturing, then vote for the Constitutional Court. History often asks nations simple questions disguised as difficult debates. This is one of those moments. The question before us is not whether we trust one government or another. The question is whether we are prepared to strengthen constitutional foundations of the Republic itself. Yes, from now, long after today's political debates have faded, long after current leaders have left office, and long after this moment has passed, future generations will live with the decisions we make today. Let us therefore choose knowledge over misinformation and participation over apathy. Let us also choose constitutional protection over uncertainty. And a Botswana where rights are protected, power is accountable, and democracy continues to grow stronger with each generation. And as I conclude, Director of Ceremonies, allow me to leave you with one final thought. That future is not in the hands of politicians alone. It is in the hands of citizens. May we choose it wisely. Ke a leboga.
Thank you very much, Honorable Ntlaile. Botsadi, ka se sebaka go etogote tiro e boela ko baruting. Yaanong ke ta kopa ene moruti o na a re tsaya kwa a re tsereng teng gore a re busetse teng ka thapelo. Mme pele ga a dira jalo ke ta kopa gore re ha re tswa we should remain seated to allow our guests gore ba tswe pele e be le gone re ka tsamaya. Ke a leboga moruti.
Life is made up of moments.